Okay, we're going to go. So thank you to everyone for attending today's program. For those of you who are joining us for the first time, I'd like to introduce you to SHALVA. SHALVA's mission is to support survivors of domestic abuse in the Jewish community through counseling, supportive services, and community education programs like this one today. Throughout the program, we may use both he, she, and he as pronouns when discussing survivors and perpetrators. While the survivors in the vast majority of reported cases of domestic abuse identify as female, we recognize that males and non-binary individuals also experience domestic abuse. And unfortunately, many of those cases are simply not reported, so that may account for the difference in the numbers. We also understand that domestic abuse is a difficult subject to listen to, so if you're triggered by anything in today's program, please reach out to your mental health professional, or you can call our offices at 773-583-4673. Also, this program is going to be recorded today, so if you need to step away and come back, the recording will be available. Now I have the honor of introducing our speaker for today's program. When we began publicizing this event, I actually heard how fortunate we were to get Danielle here for this program today, and that she is one of the most knowledgeable people in the state about OPs and DV in general. So Danielle Ruffatto became an attorney with the goal of using the law to serve those who otherwise would be unrepresented. In her current position as Ascend Justice's Managing Director of the Family Law and Protective Orders Division, she manages all aspects of the agency's services related to OPs, including their walk-in clinic, remote OP hotline, and representation cases, and oversees the family law program. Prior to this role, Danielle served as the Director of Emergency Services. She joined Ascend Justice as a staff attorney, representing clients on OPs and family law cases. She later served as the Director of Pro Bono and Training. Before joining Ascend, Danielle served initially as the staff attorney and then as the Executive Director of the First Defense Legal Aid. You can read more about her educational background in the materials. Today, Danielle will be running her slides herself. So I will be able to be more focused on the chat and the Q&A. So please pop your questions that you have for Danielle into the Q&A, and we've left a few minutes at the end of the program. All the materials are available on our website. They should have been sent to you, or they'll be available on the page where you registered for today's program. So with that, I'm going to turn it over to Danielle, and I'm going to hide myself.
Thank you so much, Vicki, and welcome everyone. I'm glad to have so many people here this afternoon, and I know that some individuals from some of our advocacy partners throughout the state are joining in, so welcome. Just a few notes really quickly about the presentation. This is designed as a nuts and bolts presentation about drafting orders of protection. Due to the limited time, we're not going to go into the Illinois Domestic Violence Act very extensively. We're not going to talk about gender-based violence generally, but I do hope that individuals who are listening to this have some of that background information. I will try to indicate where I'm referring to something that might be a Cook County specific procedure, or, procedure in a certain courthouse. But most information and the forms I'm using are the statewide forms, so this should be applicable to everyone. And then this is designed for attorneys. So I will be speaking as if I'm speaking to licensed attorneys, but I also know that there are some advocates and other agency staff that are here, and most of this is applicable to you as well. Please feel free to put questions in the chat, and I know that Vicki will be handling those. I am going to share my screen and start my presentation. This is my contact information, so if you have any questions that we are not able to answer today or something comes up down the road, please feel free to email me. Okay, so I work for Ascend Justice, which is an agency that is located in Chicago, and we aim to empower individuals and families who are impacted either by gender-based violence or the child welfare system. And one of the things that is a main focus of our agency is providing holistic legal advocacy, meaning that the attorneys in our different divisions and our client support coordinators work very closely together to try to make sure that we're meeting as many needs of our clients as we can in-house, and then if need be, referring them, but giving targeted referrals that are specific to their needs. So I'm going to jump right in to filing for an order of protection. And the three main things, that pieces of paper, essentially, that are required for filing an order of protection anywhere are a summons, because the person who you're filing against needs to be served. Petition for an order of protection, which is a form pleading that is available statewide on the Illinois Supreme Court Forms website. And then we always do an affidavit, which is attached to the petition. In Cook County, we are also asked to do a cover sheet and a sheriff's information sheet. In other counties, there may be other paperwork that you're required to complete for the sheriff or the court or the clerk's office. And then finally, in some cases, you'll be asked to actually draft an emergency order of protection. Practices may vary, and this seems to be more common in high volume courthouses. But if a lot of orders are going to be entered by the same judge, it can be very taxing and time consuming for them and their clerks and coordinators to fill those orders out. Okay. So everyone will, if you have not received the PowerPoint, but you should have received a packet of materials. And one of those things that is in the materials is a sample set of paperwork. And it starts with an affidavit and then also has a full set of order of protection paperwork. So we always at our agency draft an affidavit and attach it to the petition, because it allows us, first of all, to provide more specific details about the relationship and the parties than is contained in the petition. And it also allows us to detail the incidents of abuse and why someone needs an order of protection. The statewide forms do have spaces to list specific incidents of abuse, but there is more information that we typically include. The affidavit should be based mainly on personal knowledge that your client has about the facts in their case. But there is some flexibility to share information that they have on quote unquote information or belief, which is information they've gathered from, say, a third party. We try to limit our use on information or belief. We want to focus on what our client has seen, heard, experienced, again, what they have personal knowledge about. Okay, so we designed our affidavit so that we spend the first few paragraphs describing the relationship. First of all, what relationship the parties have, and there always is a family or household relationship in NOP, whether they have any children in common, and information about those children, if they have ever lived together, and when they separated. So that's a good overview. We also, if there are other legal matters pending, for example, if there's a post-decree divorce case, we might include that information right up front, when the divorce was filed, when it was finalized, who was given, significant decision-making responsibility, if there are kids in common, just so the judge who's hearing this, if it's an emergency judge or someone who's unfamiliar with the case, they learn the lay of the land really quickly. And so then we get into the incidents of abuse. And first of all, we're laying the foundation to introduce these incidents in court. So it's important as much as possible to put the time, date, location, who was present, and then go into the specific details of the incidents. One thing that can trip people up, especially if they're preparing this themselves, is that they intend to focus on things that are actually conclusions. That they were abused, saying this person's stalking me, harassing me, threatening me. But those are forms of abuse under the act, and those are findings that the judge needs to make. So keeping in mind, we want to put specific details about what is happening that made this person come in to get an order of protection. And it is also important where possible to include specific details, such as the number of phone calls someone has received, the last phone call or text message that's unwanted that they received. If there is the ability to directly quote things like names or specific threats, do that. If there's not, you can, summarize, of course, but to make it very clear to the judge exactly what's going on. Saying somebody is harassing me by calling me all the time is not as impactful as saying that this person is calling me approximately 20 times a day, leaving voicemails where they're threatening to send someone to beat my ass, and saying that they're going to let my dog out in hopes the dog die. These are really serious statements, and just trying to summarize it does not do it. The other thing, which should be clear by the fact that I just swore, is if there is offensive language, if there is swearing, if there are threats, put them in the affidavit. It is, again, it's not as impactful to paraphrase something to make it sound nicer. We are trying to make it very clear to the judge what is going on that's making this person feel like they need the court's protection. This is not where we're trying to make something sound nicer. All right. Also, we always start in reverse chronological order. We start with the most recent incident or series of incidents or the most recent phone calls. And we often refer to other things, like after the incident described in paragraph B, here's what's going on. So then we're incorporating that into essentially why this person needs the order, and incorporating what has happened in the past into everything that's going on recently. But we do want to make sure to make it clear, especially if we are looking for an emergency order. The other thing is include all the specific incidents that your client can think of and remember. There is not a statute of limitations on incidents in an order of protection. And in fact, the opposite is true. The statute directs the court to consider things such as the pattern, frequency, severity of past instances of abuse. There is also a case that is contained in the materials, Richardson v. Booker, which is an Illinois appellate case, which I believe just came down in 2022, that explains that and finds that the court should consider past instances, even if the person sought a remedy at the time. So we sometimes have cases where somebody has sought an order of protection, but then dismissed it, or sought criminal charges, but then decided not to pursue those. And those are incidents we include. We explain what happened to, after those incidents, but often dropping orders, not proceeding with criminal charges, often that is part of the cycle of abuse. And it's important for the court to consider all of those things. We also usually, if it's, unless the case doesn't call for it, have a summary paragraph where we explain what happened throughout the relationship. And it allows a description of what has been happening on a routine basis if the client is not able to remember every specific incident, even just that there have been other physical incidents, that the emotional abuse is happening on a regular basis. It can also allow things that don't quite fit well into one specific incident, such as controlling behavior, such as, cutting off contact and isolating a survivor, such as financial abuse and limiting access to, say, joint funds. Those are all things that are important for the judge to know about, but sometimes you can't just lay them out in one discrete incident. Okay, so in terms of an affidavit, I covered some things that we should include: specifics, all of the incidents of abuse, relationship between the parties. But there's one more thing that I think is very important to include for several reasons. And there also are things that, for other specific reasons, I recommend not including. The first one is if there are quote unquote bad facts. And what I'm talking about are sometimes situations where a client who comes in, who's filing for an order, may have insulted the person they're filing against. They may have in some way, and this is hard for me to say because knowing how these situations play out, but so things that could be, let's say, considered instigation, where they're asking, they're insulting the other person, maybe they even slap the other person or push the other person. The reasons, there's a few things. Reasons why I think it's important to include those things are number one, as a litigation strategy. In my experience, it actually builds credibility to have clients admit the whole story of what happened and to say, yes, I shouldn't have done this, but here's what happened after, which was completely out of proportion, and makes me fearful. And maybe this is the one time that I ever initiated because there's been this history of abuse and I just snapped. And that is typically far better received in my experience than having a situation where that isn't revealed. And then you get to a contested hearing and there's all this information that was left out that the respondent then provides. Again, I think it creates a credibility issue. The other thing is, just to be clear, if you're an attorney, we have an ethical obligation under the Illinois Rules of Professional Conduct to share all relevant information at an ex parte hearing, not just facts that are helpful to our clients. And to further just mention, I mentioned that there's a strategy I think involved. There also are very specific instructions in the Richardson case about what a court can consider and how a court should consider behavior such as quote unquote instigation. And it's very favorable to the petitioner in that case, because what the statute says that the court should do is first find if abuse has occurred, and then look at things like look at the standards of self-defense and whether those were met. And the trial court in Richardson did not do that. So that particular case really gives a lot of instruction to courts on how to better address situations where at least the beginning of an incident might seem, at first glance, like it's something that involves both parties. Here are some very specific things, though, that I would not include. Immigration status, which by Illinois statute, if somebody is undocumented, you should not include that. But also, if somebody is undocumented, the trips in and out of the country, that can be harmful for immigration relief down the road. Parenting or marital complaints that don't rise to the level of abuse or endangerment. And this is tough because when we meet with a client for the first time, they sit down and they tell us everything that they are upset about. And often there are complaints that are not something that I would consider abuse mixed in with the things that are abusive. And it can sometimes be hard to limit things because clients are upset and they want to tell judges all of the things that they're upset about. But for the purposes of a protective order, what's relevant is the abuse that has occurred. And so not to, make light of the fact that, say, the other person has cheated on the client, or that the client doesn't, agree with their parenting methods or how involved they are with the kids. Those are fair complaints. There are a lot of complaints that are fair complaints, but we are trying to limit this to specifically things that constitute abuse under the Domestic Violence Act. Details if there is or is likely to be a related criminal case. Now, orders of protection and other protective orders can be sought in connection with certain criminal cases, but there are a lot of reasons and situations why that where that does not happen. And sometimes, again, for very good reason. If, though, there is an investigation going on, or there has been an arrest and someone comes in, or somebody tells you this just happened yesterday, the state's attorney's office is closed, or they said they'd call them back tomorrow, but they really want this protective order today for their safety. That is when I would do something totally different than what is in the affidavit. And there actually is something that is in the affidavit, which limits what there's actually is an example of a situation where the respondent is speeding and the incident begins when the petitioner tries to get out of the car. But all we have listed is that they're physically abused, and during the physical abuse, here are some things that happen. It's not play by play. It's not very specific. It's not specific about how many times, how long something was going on, because that is something that can be an issue later on if this affidavit is brought up in that criminal case. We don't want somebody to be impeached using their affidavit. The last thing, and this is a policy that we have as an agency, but we do not reveal that a client is specifically staying at a DV shelter, or where, or even I would say that they are receiving other DV services. Sometimes it can seem relevant because the client has fled abuse and they're scared, or because they learned about the option of seeking an order of protection by connecting with a counselor or an advocate. But that creates a risk of the location of the client and that shelter or that agency shelter being discovered, and that can be a huge safety issue. So I personally would recommend that is not disclosed. The fact that somebody had to leave and is staying at another or an undisclosed location right now should be enough of an indication to the judge that they don't feel safe. Okay. So now I'm going to talk a little bit about the court form, which is the petition. So we have in Illinois form pleadings, so you don't draft a pleading or a complaint like you would in other cases. There is a checkbox and fill in the blanks. And it covers the petitioner's need for an order and for the specific remedies granted. So it lays out all the legal justifications and all the findings the judge needs to make to order these things. It asks for some basic information about the party, such as the relationship pursuant to statute, covers venue, jurisdiction, and then goes into the remedies. So why would someone want an order of protection? What can it do for a petitioner? So one thing to keep in mind is that an order of protection is not a one-size-fits-all order. A lot of people think order of protection and they assume stay away, no contact. It can be that. It can include a lot of additional remedies, or it can be very limited and not include no contact and stay away provisions. So the IDVA allows a lot of flexibility and ability to request specific remedies based on someone's situation and needs. What types of remedies are available? There are a lot of them, and they are grouped in this slide into 4 different areas. And the first one is to limit abuse and sometimes prevent other contact as a means for limiting abuse. And that's one of the recognized purposes of the IDVA. So it allows prohibiting specific types of abuse. It allows things like ordering the respondent to stay away, which means no contact at all, give them exclusive possession of a residence, provide protection for other addresses, so on. There are also a lot of temporary remedies related to children in common between the parties. And it allows the court to award physical care to the petitioner, which can be hugely important, and also order eventually child support, temporary decision-making responsibility, and do a variety of different things for temporary parenting time, depending on the circumstances. The act also allows the court to protect or reimburse for damages, expenses, deal with issues related to property due to abuse. So one of the things is payment of, the court can order eventually payment of expenses related to the abuse. So if there is property, a car window that was broken, a door that lock that was broken during an incident, if there was medical treatment that was obtained and there is a cost to that, the judge can order the respondent to pay those things. And then there is a general other remedies to increase safety that's sort of a miscellaneous category. But those include some very important things. One is ordering the respondent to go to various types of counseling or treatment, prohibiting firearm possession and ordering a respondent to turn that over, allowing a cell phone number to be transferred if the petitioner's number is on the respondent's account, basically ordering a cell phone provider to sever those accounts so that the petitioner can take over their own. And then finally, other injunctive relief, which is gives the court broad power to order other things that might make this petitioner safe. So, remedy considerations. What are we talking about here? What are we considering when we're talking with a client about their options? One thing is that there are, and if you read the statute, it will lay this out very clearly, but only some of the provisions in an order of protection can lead to arrest for violations. And they are some of the most basic ones: no abuse, stay away, no contact. But I want to be clear that every individual remedy cannot necessarily lead to an arrest and a charge for a violation. That's sometimes difficult to explain. We're not always, when we talk with clients, we don't always have the time to go through every single remedy, but I think it is helpful just to make sure that we're clear that, generally speaking, the big, most important remedies can be enforced by the police and the state's attorney through criminal charges, but it's not everything. The other thing is there are some options and things to consider when you are working with a client and they're pursuing an order. So they have the option of requesting a complete stay away order, which tells the other person they can't have any contact with them, including through third parties, has to physically stay away from them at all times, versus allowing some contact. And there actually is a provision of the statute that specifically says that a respondent can come and remain in the home but not while they're under the influence of alcohol or drugs, and therefore they constitute a threat. And there's a lot of area in between. We can write an order that isn't a complete no contact stay away, but says don't come to my home and don't come to my workplace. Or we can try to write in some more specific contact rules in the other injunctive relief section. I think the key things to keep in mind are, number one, we want to make sure that the order doesn't contradict itself. So think carefully. And number two, keep in mind that some of these are arrestable and some are not. So if we have a stay away, no contact, that's checking the box, that is all encompassing, and that is absolutely arrestable. If we start adding contact provisions under the miscellaneous remedies provision, those are harder to enforce because they're not stay away under the law. The other thing is, if somebody has a residence, and most people have a residence, whether it's a shared residence, whether it's formally shared, whether it is an undisclosed residence, the Act gives them the ability, as long as they have a legal right to be there, to get exclusive possession. Exclusive possession is a very, very strong remedy. It says that somebody cannot come there or remain there at any time. The Act also allows the court to order stay away from certain addresses like workplaces and schools and other family members' addresses, but that is limited to when the petitioner or protected parties are present. So the reason that is important is that, first of all, a home address should not be listed under both exclusive possession and stay away, because those are two different remedies. And again, one only applies some of the time, one applies all of the time. So our strong preference is to grant the petitioner exclusive possession of where they're staying, or ask the court, I should say, request it. We're not granting anything, but request on the way they're filling out the paperwork, rather than just stay away, because it's a less strong, exclusive possession is a stronger remedy. The other thing is visitation and safety considerations. So first of all, and generally, and I think this is true of all cases, but specifically situations where one person is accused of gender-based violence, to make visitation schedules extremely specific and include dates, times, when they start, when they end, and exchange information. Where are exchanges happening? Who's responsible? Are they occurring at home or at a third party, a third location? Is a third party bringing the kids back and forth? Those are things that are really important when you're dealing with somebody who has a history of being manipulative. We can't allow wiggle room in our visitation arrangements. But because that can lead to further abuse of the petitioner. But there also are safety considerations if someone has been abusive towards the children, or abusive towards the petitioner in front of the children. And so one, as well as other things, as well as using visits as an opportunity to harass the petitioner. In terms of restricting visitation, the IDVA has specific language, and it is not what is in the Marriage and Dissolution of Marriage Act. If we're talking about any sort of restrictions, supervised visits being the strongest, but also doing having the parties not have any contact even during visitation exchanges, doing them at the exchanges at a third place. Maybe if somebody has a history of not putting a child in a proper car seat. Maybe they can't drive with the children. Maybe visits are a shorter time period. There's a lot of things that can be done to increase safety and address specific concerns. The other thing, though, is if we have an order that says no contact between the parties, especially if we're talking about a plenary order, it is difficult for the parties to honestly follow that order, because it can create a situation where there is some completely understandable circumstance. Somebody's car breaks down, one of the children is sick, and they can't communicate with the other parent to explain that they're not coming to visits. And so we like our orders to be complete and also be something that is going to work for the people who are involved in them and for the parties. So we always create some form of emergency contact. And yes, this is a carve out, but we try to make it as narrow as possible so that it might be contacting a third party. It might be using an app such as Talking Parents, but that the only contact that is that is allowed is in this circumstance using this method. One thing I want to be clear about is that contact between the parties is not required for visits to happen, and kids can be protected on an order of protection and visits ordered. And so there can be an order that says no contact, but then also allows the visits. Visits are an exception to the no contact provision. Sometimes there are a lot of misunderstandings that, like, if for there to be any sort of contact between the respondent and kids, the kids cannot be mentioned at all in the OP, and that is not correct. Okay, other petition issues or factors. One that's very important is you can omit a petitioner's address, but you have to provide a mailing address, a PO box. If you're the attorney of record, it can be your address where the petitioner can receive court notices. And then also that there is this miscellaneous remedy. And we often use that, as I mentioned, to add carve-outs. Or also it can be used and is intended on being used as a way for a court to order additional relief. One of the things that is common for us to request is if the respondent has particular videos or pictures that are revealing of the petitioner, to order that they not send those, that they not disseminate them, or other information about the party, about the petitioner that they've threatened to share with other people. We often ask the court to use that to specifically say you cannot do those things. Okay, finally, this is just kind of a cheat sheet of the other paperwork. As I mentioned, the summons is really, we're looking for an address where we think the respondent can be easily served. And the emergency order, if you are asked to prepare one, it's basically has the same information as is in the petition. There isn't a great difference. But I do believe, and I don't want to misspeak, that let me see, that there is a samples emergency order of protection in the materials. Okay. All right. I think I am going to try to save the questions for the end, if that is okay, but please put them in the chat as you think of them so we don't lose those things.
Okay. Yes, Danielle, I believe that emergency order is in there. If not, we can send it out.
It is. Yeah, I double checked. It's okay. All right. So when you're working with a survivor, I would there are some things that you can do to make the situation, the experience less traumatic for them, and also to make sure that you're getting the information that you need. And keeping in mind that when someone comes in and they've experienced domestic violence, they've often experienced repeated trauma, and they may be showing signs of that trauma. They also may never have sat down and told anyone all of this together. They may have never seen themselves as somebody who's experienced domestic violence, as a victim or survivor. They may be just completely overwhelmed by realizing how many other people are experiencing something similar to what they have experienced. So some simple things that you can do, build trust. And one thing that is helpful is to explain your role and confidentiality, and also sometimes to explain why you're going to be asking the questions that you're asking, what's needed, and giving an overview of the process. So not just jumping into what happened yesterday, but giving a little bit of an overview can be very helpful. And the other thing is how to ask questions. So I find it very helpful to start by asking someone why they're here, why they feel like they need an order, and give them a little time to talk. I know they're not going to answer every question that I have. I know that I'm going to need to follow up, but to give them a little bit of time to just explain from their perspective what the most important things are, what the things are that are their biggest concerns at the top of their mind. The other thing, though, is that you will need to follow up and ask questions, and that is part of your role. And I think it's challenging sometimes to find a balance, and it definitely comes with practice, being able to find a balance between being empathetic and listening and actually hearing what the client is telling you, while at the same time keeping in mind what you need to know and getting to that point where there's an affidavit that has time, date, location, what happened in sort of a clear manner. You will need to ask follow-up questions, but the way in which you ask questions can make a huge difference in what you get back from your client. So, first of all, is tone is very important. We don't want to make anyone feel like they are being interrogated or they're being accused of something. But another sort of on the other side of things is don't feel bad asking questions that you have, because if you have them, the judge will have them. And it will be way better to establish what happened, to figure out why an action was taken or not taken in a room with you than it will be when somebody is up in court and a judge is trying to get through a bunch of cases quickly and just asking point blank, why didn't you call the police? Why did you do this? So sometimes it is about your tone, but absolutely do not assume. That is the biggest mistake. Assuming that, say, someone left when an incident ended, assuming what happened next, that the parties have had no contact. Those are situations that can really kind of lead to getting in trouble. Obviously, simple things like being encouraging clients, that they're not to blame for anything, to not, it's important to look forward, not look back. Don't blame themselves for not coming in earlier. Part of this is all about how the cycle of violence works. And sometimes clients are embarrassed. They feel bad because they forgave the person in the past and gave them another chance. But none of that is any reflection on them. And what we want to focus on is the fact that they're here now and what we can do and work with them to do to make them safer. The other thing is to be empathetic. So again, clients are often in crisis, they're stressed, they've experienced trauma, they may not have slept at all the night before they're sitting in front of you. They can be impatient, they can have trouble remembering details about the incidents. They cannot be expected, and I don't think it's fair at all to expect somebody to understand or to know innately what is important to their case and what is not. That's your job, not theirs. Sometimes though, practitioners get impatient because, well, okay, well, I don't care if he cheated on you. I don't care about why you need a divorce. I want to talk about abuse. Well, sometimes there isn't a very, sometimes there's a gray area of what is abusive, what's not abusive. All of these things are making this person feel terrible, which is why they're telling you them. So keep that in mind. And yes, it is your job to sort through them and explain what's relevant and what's not, and what the judge needs to hear today and what the judge doesn't need to hear. But you can do that with some empathy without getting frustrated with them. And also, victims of trauma often have issues because of how trauma impacts the brain with being able to recall details, to recall things in the order that happened. So just be prepared to jump around a little bit, to have to say, oh, you mentioned this incident that happened. Can we hold that for a second and finish up the incident we're talking about right now, and then go back to it? Again, that is part of trying to sort out what has happened when someone's sitting down and telling you about potentially years of abuse. Okay, so what is required and why might somebody want to grant an emergency order? So the statute and the site is right here. The purpose of an emergency order is supposed to be to prevent harm that would occur or would likely occur if the respondent had notice. It's to prevent someone from getting notified that petitioner came to get an order of protection and harassing them more. We want an order in place protecting them if that's a threat. Practically, a lot of judges consider how recent the abuse is, and specifically what happened, why somebody is here today. To respond to that, I think it is very important, and I mentioned this in the affidavit section, to include the most recent incident or behavior. If something has been going on for weeks, you can put that it's been happening, but you want to include that it's, beginning in or around mid-September and continuing to the present, and say the respondent has contacted me 3 times while I have been preparing this paperwork, or while I've been sitting in court, or they last contacted me at 1:04, they texted me at 1:04 a.m. this morning. We want it to be clear that this is something that is ongoing and persistent. Also, if there was a delay in seeking an order, expect the petitioner to have to explain why. Or the judge to ask, or the judge to be confused as to why they're there seeking an emergency order. So our strategy is to put to try to answer all of the questions we think a judge will have in our affidavit. So they have all the information they need, and we know the answers to those questions before our client goes up to court. So what I think is helpful is if they're telling you, and every judge has their own threshold, and this very much varies, but if someone is telling you that they have not, that something happened 2 weeks ago, we're going to ask, okay, well, what made you come in today? And often that brings out another incident or some, again, ongoing harassment, stalking that we didn't know about that we're going to put in the order. Sometimes, though, it's something else. They didn't know an order of protection was an option until they spoke with someone and learned about it. They sometimes thought that they filed a police report and that was going to lead to criminal charges. And then they followed up and realized that's not what happened. So they thought, steps were being taken and they weren't being taken. The person might have, this might be the first time they were able to get childcare. It might be that they went, that honestly, we've had situations where somebody was in the hospital getting treatment as a result of the most recent incident. And this is the first time they've been able to come to court. So I would encourage that. I would encourage you to ask those questions beforehand and spell it out in the affidavit. So whether the judge is going to consider those factors or those circumstances or not, it is in the order. And based on the statute, that's not exactly what they should be looking at. They should be looking at what may happen when service occurs on this case, and is there a greater harm of abuse without an emergency. Okay, so when should you request an emergency? What's the process? Why or when would you want to file? And when would you maybe not want to file? So one thing to be clear is, like in any other case, you should be able to file a petition and all of the required documentation and send it out for service, and then have a court date where after both parties are served and see the judge. That's typically how things happen. There might be some pushback in certain jurisdictions or in certain courthouses, because most often what happens is that someone comes in and files for and requests an emergency order, and the judge makes a decision on that, and then the case goes forward. There might sometimes not be the best mechanism to say set a court date on a case that you're just starting, where you're filing a petition. But in an OP, we're not going to serve the respondent and wait for them to file a response and then, set a court date in 3 months. This is a pressing issue, regardless of whether there's an emergency order issued or not. So some pros to filing for and requesting an emergency order is that it takes effect immediately. So if one is granted, it provides that protection. It's very rare in my experience to have someone come in who doesn't feel like they would be in more danger if the respondent if the respondent was served and they didn't know. And the other thing is, usually, again, there's some reason why somebody feels like they need this now, and that's why they're here. And so there usually is some argument, some reason. There could be situations where something is obviously not an emergency, and we don't want to, anger a judge that the client is going to be in front of in the future. So that is a thing. And there could be the possibility that a judge might dismiss the case altogether. The judge should have, there really are a few options. The judge can grant an emergency or not grant one, but they can also keep a petition pending. So it's not, if a judge denies an EOP, that means the whole case gets dismissed. But I feel like sometimes that can be like the natural thing that happens. The judge doesn't get why this person is seeking this order, and they just go ahead and dismiss it when there may be a basis for a plenary order. And also, if you're an attorney and you're already involved in litigation, such as there's a domestic relations case pending, you might want to consider how that's going to impact the whole case and whether you can work, especially with opposing counsel, that whether there is another way to resolve this, because OPs can, in that context, sometimes be seen as the nuclear option. One thing to keep in mind, and this doesn't come up that often in our cases, but if there is a situation where a client really feels like they're not safe with an EOP and the judge denies the EOP but says, okay, well, we're going to let the petition go forward, this is your client's petition. They can choose to withdraw it. They can ask that the case be dismissed if they are really so fearful. This might seem counterintuitive, because if they are so fearful, that would be the reason why the judge should give them an emergency order and everything should work out the way it's supposed to. But occasionally that doesn't happen, and someone is just terrified of the ramifications when the person gets served with the order of protection. So that is an option. It doesn't get the client any further towards safety, but it doesn't put them in a worse position than they were in when they walked in the door that morning to ask for your assistance. Okay. Hearing on an order of protection, and I know we only have a few more minutes, so I'm going to go through this last slide quickly and then address questions. So a few things. This is focused on things that I think are particular to protective orders cases. Obviously, if you're going to have a contested hearing, you're going to do all of your normal prep work, but a few things that might be very important for these cases. One is to check with your client to make sure they still want to proceed. They may change their mind for a variety of different reasons, but that is more likely in a protective order cases than in some others. The other thing is that the evidence, if any, exists in protective order cases and orders of protection often involve things that the client has the easiest access to, such as pictures or screenshots of the actual content of text messages. This doesn't eliminate the need to subpoena or, issue discovery in your cases, but a lot of the evidence can best and sometimes only be obtained from your client. So we want to know what they have. We'll prepare it when preparing. It is really important to explain what's going to happen in court to prepare them for controlling their emotions in court. This is an emotional case. Also, I think it is extremely helpful to go over refreshing recollection and what happens if they completely blank in court because they are nervous, sometimes not just about testifying in court, as everyone is, but of their concern for the personal safety when they walk in and they say what happened in this situation. They're facing somebody who in some cases has been extremely physically abusive towards them. So keep that in mind. It can give a lot of comfort to know that there is like a mechanism and that everything is not lost if they blank. Find out if they had any contact since the OP was entered, when and how and why. We've had, there was a death in the family. So I texted him to let him know. Okay. I will say that judges will generally hold it against somebody if they're saying they need an OP and there has been contact, but there are life circumstances that make it much more understandable. And then also prepare a closing statement. And two things not to miss are why an OP should be granted specifically based on this behavior. And a lot of times that falls on what harassment is defined under the IDVA. One thing else to be specific about is the Domestic Violence Act does not require that there be multiple incidents of abuse. It doesn't require that abuse be persistent. So this is something that is important to just make sure that, especially if you're in front of a judge who's not as familiar with orders of protection and what the law says. But also, why will relief should be granted if it involves balancing the hardships or is any sort of unusual or less commonly used form of relief. Okay. All right, so I have a few minutes for questions. If it's okay, Vicki, I'm gonna start with the questions that are in the
Well, we only have the Q&A questions because we did not turn on the chat. I did not set it up that way, which I remember why I did that, and that's because that way all the questions are in one spot. We don't have to bounce back and forth between.
Okay. So one thing I want to do, just because I know some people may need to go, is
thank you.
Yes.
Here's the survey. Appreciate that.
So our survey, and is this required for CLE credit or is this just for feedback?
It is for feedback. I can say that if it's going to get more people to do it, yeah, it's required for CLE credit.
But I will say, I know this will be shared with me. I appreciate your feedback and your comments. Absolutely.
And Danielle, before you start answering questions, I just want to say thank you so much because Danielle is the perfect example of what a trauma-informed attorney does. The things that she talked about today and the way that she works with clients and meets them where they are and really tries to understand each client's circumstances is truly to be applauded, and especially during Domestic Violence Awareness Month. So Danielle, thank you so much for what you do.
Thank you. That's a very high compliment. So thank you. I appreciate it.
Thank you so much.
Okay, so I'm going to go through the questions that are on here. Obviously, if you have to leave, please go ahead and leave, but feel free to email me if your question didn't get answered or if anything else comes up. A few of these I think I can answer really quickly. One is there such a thing of the victim violating their own order? And the answer is not really in most cases, but it is something that gets mentioned often. So orders are designed to be one-sided. They typically have put constraints on the respondent only. There are some exceptions like visitation that bind both parties. However, so no, there is no way in Illinois for someone to be arrested for violating an order. The order says, respondent, you can't contact petitioner. However, it is something that judges commonly look at when they're considering whether a plenary order needs to be granted. So it's not advisable if you are saying you want the person to stay away and not have contact with you. That is sort of assuming that they don't that you don't want to contact them. That being said, so that might be harmful to the case, but no, they can't exactly do that. Does exclusive possession actually force respondents to stay away from a residence? It is a remedy that says that they cannot come to or remain at the residence. And typically it should be executed by law enforcement. So yes, it should be that the respondents have to leave and not come back to that residence. Sometimes it can be difficult in terms of like how far away and what's reasonable. But yes, that should remove the respondent from the residence and make them not able to come there. Okay, there's a question: if the respondent needs to come to the home and they come with the police, can we stop them coming over? So the order should address this, even in an emergency order. The court often requires and puts in the order, and it's something that under the statute the respondent should be allowed to do, to come get their belongings under certain circumstances. If they come with the police, I would say that, in my experience, the police often do this even without an order of protection because it helps eliminate issues if they're there when someone goes in to get their belongings. If the order doesn't say that they can come to the residence and there is an order, I would say that you can say the order doesn't allow this, but they are going to have a right to get their belongings some way, shape, or form. So I would just be prepared for it. Can electronics be added in circumstances where a tracking device has been put in an iPhone? Can electronics be added in terms of, I'm a little confused by the question, so we might have to follow up.
Let me see if I can get Sherry. Move on to another question and I'll get Sherry.
I always put the client's place of worship. No one wants to see their abuser at synagogue or church. Absolutely. One issue that we face sometimes is if the respondent attends the same congregation, but if they do not, there's no real reason for them to be there. So yeah, absolutely. That's a place that we protect as well.
Okay, I can get Sherry back on.
Okay. Yes. So there is this question about how likely is restriction when the respondent has been physically abused in front of them. And there also are, there are huge, so I will say that there are huge links between between abuse in the home and child abuse, domestic abuse and child abuse. So it is absolutely a concern. And so how likely is a restriction on parenting time? That's going to vary greatly by the jurisdiction, the judge, and the circumstances of the case. I will say that it is common for us to ask for visits to be reserved in an emergency order, because it's really difficult, if not impossible, to come up with a strict visitation arrangement. When I say strict, I mean like very clear, I guess I should say, in a circumstance where only one person is in court. So because it might be dangerous to the kids, because we don't know when this person is going to be served, and if they'll even know that this is this setup, to have visits be reserved during an EOP. In my experience, a lot of judges like that because they like to have both people in court in front of them before they order any visits. In terms of restricting parenting time, I mean, the act allows it under a lot of circumstances. The respondent might not act in the best interest of the kids. The respondent is likely to use visits as an opportunity or a reason to harass the petitioner or family, as well as that they may abuse or endanger. So there is a much greater likelihood and legal justification for having visits restricted in some way in an OP than there is in a family law case. Serious endangerment is not required. So I think it's fair to make the argument for it. And if visits are going to be ordered, that if there is any danger for any of those things, that appropriate restrictions are put in place. Absolutely. Okay, are EOPs required to obtain a plenary OP? No, absolutely not. You do not have to have an emergency order. An emergency order can be denied. An emergency order absolutely does not need to be granted to request a POP. Somebody posted that judges do not add places of worship. Yeah, and it is going to vary. I do think it's a fair request if the other person does not. I mean, it's much more complicated if both parties go to the same house of worship.
Yeah.
Okay.
Can we get back to Sherry's question because she's available?
Sure.
Sherry, do you want to go? Because I think it's important.
Sure.
Well, hi, can you hear me?
Yes.
Yeah.
Oh, thank you for this. I was just wondering, sometimes we have issues where, that the parents have to provide a phone for the kids, or, the iPads go back and forth and tracking devices are found on that, or stuffed animals when the kids are younger. And I guess, have you, in your experience, has that ever been requested, or do they often allow that on the order? Because I personally only write up the criminal ones where a state's attorney signs off, so I don't do that part.
I would say that I have not seen that in an order of protection that is a standalone order of protection. I have seen that come up in family law cases and domestic relations cases where things are going back and forth. But absolutely, it would be a reason to file a motion and ask that be modified. And I would say that there can be like specific tracking apps, or like, using what are they called, like Apple, like air tags, like that should not be occurring. But another thing that can be concerning is if the family's on the same plan and they all have like iPhones, that you can just use Find My iPhone to figure out where somebody's at. Like there are tracking convenience focused ones that can be very helpful if you're not in an abusive relationship, but that couldn't be put on, under surveillance. So I would absolutely think that, I absolutely would, if we found out that a client was, actually, this did happen in one of our family law cases, and I believe we filed a motion because a phone was going back and forth and being used to, we think, try to figure out our client's location. Yeah. So I absolutely would say that, if that is something that is occurring in a case or someone is concerned about it, that should be raised. And I've never seen an order of protection with the limited visits in an order of protection, involve being that the other party has to like send back a phone. But again, that does happen in more involved cases, domestic relations, because there's a lot of litigation often around kids. But I think that is an absolute fair concern. And just generally being under surveillance using technology is a concern. Okay.
you.
Yeah, and the last one is an advocate if a petitioner admits instigating situation. So what I can say is that I would probably give the same advice, because we do this even in cases where we're providing brief services, where we're not going to be up in an emergency order of protection. So we're not going to be up there in court explaining this to the judge. There absolutely is, the possibility, especially at an emergency stage, that it could backfire, that the judge could see something and say, well, I'm not giving you this emergency order. But I do think that if the client's goal is to eventually get a plenary order, that the possibility is greater that the judge doesn't give them the order. If there's information that they didn't share that the respondent brings up. So I think that would be true. And I believe that I already answered the one about exclusive possession. So I think I am done with all of the questions that are in the Q&A. Thank you all for coming, and thank you so much for your wonderful questions.
Yes, thank you very much. And thank you again to Danielle. I just wanted to say, please, please, please take the survey. The reason we can make these free services like today's program, or our counseling services, or our legal liaison program, where we have an in-house attorney that helps guide our clients through the process. She doesn't always represent them in court. Most of the time we actually look to you as members of the family law community to represent our clients. So if that's something you're interested in, please reach out to me, vrivkin@shalvacares.org. Also, these services do cost us some money, and it's done through the generosity of the community. So if you're interested in supporting Shalva services, you can also text HOPE to 345-345. And any other last thoughts, Danielle? Otherwise, we'll let everyone go. Okay.
Oops. No, thank you so much.
All right. Thank you. I'm just going to put this link in here to everyone, and we can sign off. So thank you so much.